They came without warning. Not through the front door, but through a loophole. That was the opening line on CNN at 3:47 a.m. when footage first leaked. Camo-clad Marines disembarking from military trucks under the hazy streetlights of South Central Los Angeles. No governor's approval, no state emergency, no official explanation. Just boots on asphalt and silence from the top. Inside the California state capitol, Governor Gavin Newsom stood motionless, phone pressed to his ear, listening to a Pentagon voice tell him what he already knew. "They've landed?" he asked, jaw clenched. "They've been operational for 4 hours," came the answer. 4 hours? By the time the people of California had heard the rumor, the operation was already in motion. And when Newsom hung up, he didn't reach for coffee. He reached for the Constitution. 1:14 a.m., line secured. Rob Bonta picks up on the second ring. "Gavin, this isn't deployment. It's a breach," Newsom said. "A breach of what?" "Of our laws, our rights, our damn statehood." There was no public statement, no televised announcement from the White House. But there was a tweet. Oh, there was always a tweet. Donald Trump. "California can't even keep the lights on, let alone control its streets. If Newsom can't do his job, I will." The retweets numbered in the millions. And just like that, the chaos had a slogan: Marshall State CA. Back on the ground, the justification trickled in like military fog. A press release from the Department of Defense claimed escalating unrest in L.A., numerous risk indicators, and a limited-time federal security operation. But the document failed to name a single act of violence. No casualty report, no law enforcement request, no coordination with state officials. "Sounds like a coup wrapped in khaki," Bont muttered, reading it. At 2:22 a.m., Newsom issued a closed-door emergency order to the California Attorney General's office. One line red-penned in his own handwriting: "No president gets to bypass the 10th Amendment. Not while I'm breathing." Meanwhile, the MAGA media machine roared to life. Tucker Carlson called it a heroic reassertion of federal law. Owen aired a loop of burning trash bins from last year's protests. The narrative was being built brick by brick in real time. And Trump, he wasn't watching the reaction. He was manufacturing it. In a now-deleted Truth Social post, he wrote, "These people think they're states. They forget they're just pieces on the board." Bont's team got to work. Statutes were pulled, precedent cases reviewed, and a draft injunction was drawn up at record speed. The goal? A temporary restraining order to block the federalization of the California National Guard and stop what Newsom now called an undeclared invasion. 3:05 a.m., Sacramento. A legal aide turned to Bont. "Sir, are we filing an ex parte?" "Yes," Bont said without hesitation. "Let them complain about process. We'll deal with legality, but right now they're breaking the damn glass." 4:17 a.m., tension spilled across state lines. Rachel Maddow opened her segment with a chilling monologue. If a president can send troops into a state without its consent, then the idea of federalism is just window dressing on a dictatorship. 5:33 a.m., San Francisco. Somewhere inside the federal courthouse, an alert pinged the system. Case filed. State of California versus Donald J. Trump. Pete Hegseth, United States Department of Defense. Presiding Judge Charles R. Breyer, a name that needed no introduction. Not to the judiciary, not to the Trump administration, and certainly not to his brother, Stephen Breyer, the recently retired Supreme Court justice who, just months earlier, had warned publicly, the erosion of judicial independence doesn't begin with executions. It begins with compliance. Now, his younger brother would be asked to make a ruling that could ignite a legal civil war. Breyer's clerk reviewed the request, a 22-page complaint demanding an emergency block of military authority, citing violations of the 10th Amendment and Administrative Procedures Act. One line stood out: "No armed force may override the sovereignty of a U.S. state in absence of insurrection or invitation. Neither is present." But Breyer didn't sign off. Not yet, because 5 minutes later, the Trump administration filed its response. A request, a stall, a legal wedge. They asked for 24 hours to respond. And Breyer, he granted it. Not because he approved, but because he was methodical. Because he knew a rushed ruling would be ripped to shreds on appeal. Because he wasn't playing checkers. 6:12 a.m., first light over California. Newsom stared out his window, a sunrise burning behind the Capitol dome. "They're going to say we overreacted," he said. Bonner replied, "Good. That means we reacted." 2:03 a.m., Office of the California Attorney General, Sacramento. "Draft the TTRO," Rob Bontes said without looking up. "We're not waiting for federal courtesy." One of his aides blinked. Ex parte. As ex parte as hell. The legal war room clicked into motion. Statutes lit up across screens. Case law flickered like battlefield tactics. The charge was clear. Stop the President of the United States from weaponizing the military against the state. The complaint, all 22 pages of it, landed in the federal docket by 11 a.m. The accusations were sharp and specific. Violation of the 10th Amendment. The federal government had trampled the sovereignty of California. Breach of the Administrative Procedure Act. The Department of Defense had acted outside proper channels. A textbook case of ultra vires behaves more like a generalissimo. Bont's signature stood bold at the bottom of the filing. Let the record show that no American state surrendered its rights to be policed by the executive branch. Meanwhile, the other side moved fast. Inside a high-ceilinged office in Washington, Trump's legal team fired back, not with facts, but with fog. The president has inherent authority under 10 U.S.C. Section 1246 to respond to insurrections, declared a sharply dressed lawyer on Fox News. Cal's inaction forced his hand. The clip played on repeat as pundits nodded like dashboard bobbleheads. If Nome can't secure his own cities, the federal government has not just the right, but the responsibility to act, one commentator declared. No proof, no precedent, but plenty of volume. Back in California, the strategy was clear. "This isn't just about troops on the ground," said Bonta. "It's about the president. If we lose this, Texas is next. Then New York. Then whatever state refuses to kiss the ring." His deputy added dryly, "So, we're not filing a lawsuit. We're filing a firewall." The name assigned to the case raised eyebrows. Judge Charles R. Breyer, 83 years old, appointed by Bill Clinton. A judicial veteran. A man who didn't flinch for headlines, but did pause for the Constitution. Inside the courthouse, clerks exchanged looks. "Isn't he Stephen Breyer's brother?" "Yeah, the retired Supreme Court Justice who slammed Trump last year." "The same." A murmur swept the hallways. Destiny had a sense of irony. 11:27 a.m., San Francisco Federal Courthouse. Breyer read the filing slowly, thoroughly. Then he sighed. Ex parte. The word lingered in the air like the smell of overcooked politics. He tapped his pen. "Courts generally hate ex parte," he murmured. "They like to have full briefing." He flipped the page, read again. But it's not every day the federal government storms a state. Across the country, Trump's team filed their response. A request, a stall. They asked for 24 hours to submit a full brief. No fire, no fury, just paper. But Breyer saw it for what it was, a delay disguised as due process. And yet he granted it, not out of deference, but discipline. Newsom received the news like a man reading battlefield weather. They asked for time or surrender. Then we make damn good use of ours. 12:14 p.m., MSNBC. A commentator read aloud from the court documents. Plaintiff Gavin Newsom, on behalf of the state of California, filed an ex parte motion for a temporary restraining order at 11 a.m. on June 10th. Then came the line that raised national blood pressure. Defendants Donald Trump, Pete Hegseth, and the Department of Defense requested 24 hours to file a response brief. Judge Breyer granted the request. The camera cut back to the anchor. "Looks like the judge wants a full fight, not a fast one." Inside a coffee shop in Berkeley, a law student muttered, "This is Bush versus Gore, but with boots." 1:32 p.m., legal forums exploded with debate. Some praised Breyer for respecting process. Others accused him of giving Trump time to militarize. But in the middle of it all, one quote stood out. It came from a retired judge in an op-ed. "Emergency orders should be rare, but when the troops are already on your streets, delay is injustice. It's surrender." 4:46 p.m., California State Capitol. Bond's legal team gathered around a whiteboard filled with citations. "We need to hammer the 10th Amendment," one advisor said. Another added, "and the APA. Their procedure was a joke. No review, no record, no accountability." Bonta nodded. "Bury them in logic," he said. "If they're going to use the military as a megaphone, we'll use the Constitution as a sledgehammer." 8:01 p.m., the White House briefing room. A reporter asked, "Mr. President, California claims you've overstepped federal authority. Any comment?" Trump leaned into the mic. "They said I couldn't build a wall. I did. They said I couldn't move the embassy. I did. They said I couldn't stop the caravans. I did. Now they say I can't keep America safe. Watch me." Thunderous applause from his base. Smirch from the front row. 11:59 p.m., Bont signs the rebuttal brief. He places it on the desk. This goes in at 9 sharp. He glances out the window. A patrol car hums in the distance. Helicopters patrol above the skyline. Troops remain deployed, but the law is moving too. Across the city, the courthouse prepares. The hearing has a time, 1:30 p.m. The country has a clock, and Breyer has a decision. The chessboard is set. Tomorrow, they play. June 12th at 1:26 p.m., San Francisco Federal Courthouse. The hall outside courtroom 6B was packed. Journalists with hot mics, clerks whispering case law, and one overconfident pundit live streaming from the stairwell like he was covering a moon landing. Inside the courtroom, the air felt charged. Cameras weren't allowed, but every seat was filled. What was at stake today wasn't just the deployment of troops. It was the reach of a presidency. It was the durability of the Constitution. Judge Charles Breyer entered precisely at 1:30 p.m. He didn't smile. He didn't hesitate. He only spoke. "This court is now in session. Matter, State of California versus Trump et al. Let's proceed." Trump's legal counsel stood tall, well-pressed, and radiating entitlement. "Your Honor, the President acted within his constitutional authority under Title 10, Section 1246. When a state fails to suppress an insurrection or cannot protect its citizens, the federal government has not just the right, but the duty to act." Breyer raised an eyebrow. "Insurrection? Has one been declared?" "No formal declaration, sir, but the facts on the ground, burned vehicles, attacks on property, constitute insurrection by implication." The gallery murmured. Somewhere in the back, someone scoffed audibly. Rob Bont rose slowly, calm, composed, razor-edged. "Your Honor, we've seen no insurrection. We've seen no formal request for help, no evidence of escalation beyond local law enforcement's control. What we've seen is unilateral federal action. That's not protection. That's occupation." The government's lawyer leaned forward. "If California's sovereignty becomes an excuse to harbor lawlessness, federal power must act." Bont didn't flinch. "We don't harbor lawlessness. We defend constitutional lines, the ones that protect you from becoming a monarch." Judge Breyer steepled his fingers. "I don't care if you call it a rebellion or resistance. What I want to know is who decides that? You or the Constitution?" Silence. The kind of silence that tastes like iron. Trump's side tried again. "The federal government cannot sit idle while a state crumbles." Bont countered without blinking. "California is standing. What crumbles is the balance of power when one man moves troops like chess pieces." A junior associate from Trump's table tried a new angle. "Your Honor, the Administrative Procedure Act does not apply in emergencies." Bont replied before Breyer could. "Then declare one. Declare a national emergency and trigger the War Powers Framework. But don't bypass the system and pretend the Constitution is a suggestion." Breyer nodded slightly. "That's a fair distinction." 2:07 p.m., short recess. The courtroom buzzed like a disturbed hive. Reporters scrambled to text quotes. MSNBC aired a montage of past military deployments. OAN ran a cheering. Trump defends America. California cries wolf. In the hallway, a TV played a clip from an interview recorded months ago. Stephen Breyer, retired Supreme Court Justice, sitting with quiet force. "The judiciary must stand. If not for justice, then at least for the memory of what justice used to mean." Inside the courtroom, Charles Breyer stared into the middle distance. He had heard the quote before. But today, it felt heavier. 2:21 p.m., back in session. Breyer tapped the bench. I've reviewed the filings, listened to the arguments, and studied the statutes. This court recognizes the gravity of federalism. It also recognizes abuse of discretion when it sees one. Trump's counsel stood as if ready to object. Breyer cut him off. "Sit down, counselor. You'll get your appeal." The courtroom held its breath. The court finds that the deployment of federal troops in California was done without proper statutory authority, absent coordination, and lacking factual justification. It constitutes executive overreach. He paused, and that overreach stops here. Gasps, then a ripple of suppressed applause. One journalist in the gallery mouthed, "Holy shit." Bont turned to his team. No fist pumps, just nods. Just breathing again. Breyer continued, "The TTRO is granted. Further federal deployment is hereby restrained. Any ongoing presence must cease unless renewed by a coordinated legal framework." Then the final line. This court does not answer to chaos. It answers to law. 1:30 p.m., San Francisco Federal Courthouse. When Judge Charles Breyer returned to the bench, he brought with him the gravity of precedent and the weight of a constitution too often treated like a brochure. The courtroom stood in silence, not the ceremonial kind, but the kind that comes when everyone knows they are inches from history. He adjusted his glasses, cleared his throat, and without raising his voice, he leveled it like a gavel across the room. This court doesn't serve the president. It serves the Constitution. A cough in the gallery. No other sound. The use of troops without due cause, without consultation, without evidence, violates the very essence of the 10th Amendment. Let me be clear. A president may act in a national emergency, but he may not manufacture one. Trump's attorney rose, face tight. "Your Honor, if I may," Breyer didn't blink. "No, you may not. Sit down." This court finds that the federal deployment of troops into the state of California was executed without statutory foundation, absent factual justification, and in direct conflict with the procedural standards of the Administrative Procedure Act. It was an act of executive overreach, not national defense. He paused. Let that land. Therefore, this court issues a temporary restraining order effective immediately, barring any further deployment of federal forces into California without explicit coordination and legal validation. All currently deployed forces must stand down and withdraw unless reauthorized through proper federal-state channels. Bonta let out a slow breath. Not relief, just confirmation that reality hadn't collapsed. A clerk whispered to a reporter, "He actually said it." Furthermore, Breyer continued, "This court directs the Department of Justice to issue immediate notification to all relevant federal entities of this order's scope and binding authority. And let the record reflect. If this breach is tolerated, there may not be many state boundaries left to defend." The courtroom didn't erupt. It exhaled. Trump's team scrambled. One aide passed a phone across the table. Another typed furiously. Their lead counsel tried to reassert control. "We respectfully file immediate notice of appeal to the Ninth Circuit." Breyer nodded once. "You're welcome to it. The law welcomes scrutiny." Outside the courthouse, the headlines had already broken. Breyer slaps down Trump troop order. Judicial earthquake in California. San Francisco to Trump. Get your boots off our lawn. 10 minutes later, Trump emerged on the north lawn of the White House. A hastily arranged press setup. American flags, some hastily ironed, framed his shoulders. Judges don't win wars. Presidents do. He stared straight into the cameras, chin tilted in defiance. But his voice lacked its usual thunder. This was a weak decision, a political stunt by a Clinton appointee. "It won't last." Reporters shouted over each other. "Mr. President, will you comply with the order?" "I don't lose. I just recalibrate." Back in California, Bonta stood at a makeshift podium outside the courthouse. His words were steady, calculated, not celebratory. Today's ruling wasn't just about troops. It was about boundaries, legal ones, constitutional ones, human ones. When a president forgets those lines, the courts must remind him. He turned to his staff. "We didn't beat a president. We restored a line." Inside the courthouse, Breyer remained at his bench a little longer. He watched the courtroom empty, noted the blank notepad on his desk, and before standing, he said quietly to no one in particular, "Law isn't loud. It just lasts." By nightfall, the courthouse in San Francisco stood quiet, but the digital world did not. Hashtags burned through timelines like wildfires through dry California brush. Hashtag Breyer verdict. Hashtag Trump troops. Hashtag justice draws a line. CNN ran the cheering. Justice draws a line. We will not go back. MSNBC went harder. One man tried to militarize a democracy. One judge made sure it stayed one. Fox News countered, a political ruling masquerading as constitutional law. Outside, camera crews still filmed the empty courthouse steps. A few protesters lingered. Others lit candles along the pavement. Someone, young, angry, poetic, had spray-painted in bold black letters, "Justice didn't shoot. It simply stood its ground." Back at the California Department of Justice, Rob Bonta faced the cameras with none of the arrogance some had expected. "We didn't take him down. We just lifted the truth high enough for everyone to see it." He paused, then added, "This wasn't about power. It was about limits." Meanwhile, at his golf club in Bedminster, Donald J. Trump stood flanked by 2 flags and a banner that read, "Law and Order, the real version." "Judges don't win wars. Presidents do," he snapped. "I'll keep fighting for this country, even if that means fighting activist courts and fake lawsuits." He didn't take questions. Clips of his statement played on loop across news networks for the next 48 hours. Some spun it as resilience, others as desperation. Then, around 2 a.m., a clip of Stephen Breyer, long retired, re-emerged, tweeted by a journalist from The Atlantic. "When one judge speaks the truth, he speaks for the silent majority of the Constitution." It was short, haunting, and by morning it was viral. Think pieces erupted across the country. The New Yorker ran a cover showing a courtroom bathed in gold light, a single judge's bench casting a long shadow over a soldier's boots. The Washington Post headlined, "A gavel against the gun." Legal panels sprang up from Berkeley to Yale. Students analyzed Charles Breyer's ruling not only for its legal weight, but for its symbolic defiance. The Constitution is not a suggestion. It is a structure. No rebellion was declared. No insurrection was evident. What was clear was the ambition of one. They underlined those sentences in red. And while pundits battled over ideology, the public absorbed something more lasting. This was not just California versus Trump. It was law versus appetite, limits versus momentum, a gavel versus a gut instinct to conquer. It was the story of an 83-year-old man in a black robe who didn't blink. He didn't give speeches. He didn't grandstand. He wrote it down, and that was enough. Enough to stop the tanks. Enough to call the bluff. Enough to remind the country, quietly, surgically, constitutionally, what lines still mattered. Outside the courthouse, the candles stayed lit through the night. Not in mourning, but in memory.